Let's move to our final question for the evening. Stressed in Southgate. And there are multiple exclamation points after that. Stressed in Southgate writes in, my former boyfriend, who is now deceased, left me a home before his death in 2014. He put me right on the title with his name as Joint with Survivorship. The deed, yeah, see?
Mm-hmm.
We addressed this in another
right.
video, folks. Right. The deed was filed about a month after his death. Last month, his brother came with eviction papers stating that he was the owner of the home. My boyfriend did not have a will, and so his brother probated the estate in 2019. He waived a deed at my face, saying he now owns it under the authority of the probate court. What do I do? Do I need to leave? I thought I owned the house. They're literally shouting, stressed in Southgate.
Okay, so they definitely need to do more than just call or write in on that question. They have to see a real estate attorney. But here's the answer, and it's kind of a complicated question. But first of all, again, we've just said this in 2 other videos. Myself as an attorney, I have to see how the deed was drafted and does it have the language that's needed. She's saying it's joint with right of survivorship. We got to see what's going on there. Okay, that's number one. Assuming it is joint with right of survivorship, that means that when her boyfriend passed, all his interest by operation of law, that means it happens automatically. You don't have to go to a court. You don't have to get it blessed by anybody. You don't have to see an attorney. It just happens. A deed can sit in the Register of Deeds for 70 years. You could have it could be a couple, it could be partners, a business partner, it could be a million different things. If people own something joint with right of survivorship, that deed could sit around for 100 years. And then when there's a death and you have the last party on that deed, if they're still living and it was joint with right of survivorship and they're the last survivor, whoever owned interest with that person, all their interest goes to that last person. They're the owner. Nobody has to do anything. That's number one. So she said also something very important. She recorded the deed. So it's recorded. What year? We know, she says, it's a month after he died. He died in 2014.
Yeah, 2014, and the deed was filed about a month after his death.
Right. Okay. So it's in the record. She's the owner by operation of law, and now it's recorded. Why do we record deeds? We want to put everybody in the world on notice as to who is the rightful owner or who has a real estate interest in a specific subject property. That's all it does. And you put everybody on notice. By law, you're protected. The law protects you as an owner, so long as it's legitimate, you're legitimately in the chain of title. The law is going to protect you, as it would not protect somebody who held the deed and never recorded it, because now nobody knows, that there's this interest. So she actually did what she was supposed to do. She recorded the deed. Okay. Now we have, I'm trying to get this right, a couple years later, the boyfriend's brother goes, and because the boyfriend had died without a will, the boyfriend thought, well, I should probate. Somebody told him, go probate the property. So he probably listed the property that his brother once owned. And unbeknownst to him, or he didn't know, he listed the property. This sounds like he did it without a probate attorney, but he listed the property as being part of the estate. And then he gets a letter of authority from the court that says, yeah, you know what? That's part of the estate. You listed it. So guess what? You have the authority to do what you need to do. You can convey it. You can refinance it. You can do all these different things. It's called a letter of authority. But here's the problem. This is the most important part of it. At the time of the brother's death, that property moves out of the estate. It's not part of the the boyfriend's estate anymore. By operation of law, it moves over to the girlfriend. She's the owner, never enters his estate. So when he went to go probate the estate, He thinks it's part of the estate. Then he makes the deed. Somebody made a deed for him. It's called a personal representative deed.
I see.
And he's waiving the deed. That's what I'm getting. He's taking the deed and saying, I own it. No, you don't. You can't probate something that isn't part of the estate. Oh, wow. That's a hard one. I mean, it's going to be hard to explain to the brother's, the boyfriend's brother. But yeah.
I don't think so. That sounds, that's pretty cut and dry. I mean,
it sounds like it, right?
Out of maybe because of personality.
Right. They obviously, there must be something there that's a little, it's not just, waving it in front like the way she said or what have you. It might be a contentious relationship, but yeah, that property never entered the estate. That's not an asset of the estate.
Sure.
But you see the confusion, right? You see how people easily get confused.
So that was going to be my question, was the question on he waived a deed at her face. So it is irrelevant that he has a deed drawn
Worthless.
Up.
Right.
Because he would not be able to go record that, correct? Because she has.
Oh no, he could record it.
He could record it, but it would
record whatever he wants.
It would be behind hers. It wouldn't.
Right.
It wouldn't like supersede hers, I guess, is what.
But it's a worthless deed.
It's worthless.
It's a worthless
he can
deed.
record a worthless piece of paper.
Right.
Okay.
You can record it. That's where, unfortunately, that's where attorneys have to get involved sometimes. Mm-hmm. So you will hear, and it happens every day, you will hear, I know you have heard this, you'll go and you'll record something at the Register of Deeds, and a question will come up, and the Register of Deeds, the clerk there at the Register of Deeds at the counter, she'll say, or he'll say, I'm sorry, I cannot give you any legal advice.
Right.
Just because they take the deed and record it, that's not validating the legal interest of any one party. That's not giving any type of decision on the validity of a transaction.
Okay.
Their job is they see, I have a checklist. People can go online on our website under Proven Resource, and it tells you what needs to be in a deed in order for it to be recorded, how a deed needs to have to appear. What are the margins? What needs to be said? What needs to be stated in order for that clerk at the Register of Deeds to accept it for recording? There's like 12 items.
Yeah.
And they go through and they check. They're not making a decision as to whether or not, the brother has a legal right or did he do the probate correctly. That's not their business.
They're just
their whole business
your
is to accept a recordable instrument and put it in the into the what we call the library page. They register this document for everybody to see, and they do it in a way that categorizes it systematically, so that if I'm looking about anything related to your property, it's cross-referenced with the legal description, with libraries, which is the volume, and then the page. Yep. Okay.
Right.
So we have that quite often. People think real estate law is boring. It's actually really fun.
It is. It is.
It is. It's like a puzzle every day. Yep. Yeah, and that's why I love it. That's why I still love it. And I like helping people solve their problems. In this situation, it's unfortunate, and it's not going to be just. I don't know these people from Adam, but when you have to tell people that they don't really have a right to something, or that they went through a legal process that was needless and expensive and you didn't have to do it, well, it's never really received that, well initially.
Sure.
So you have to kind of sit down and, right?
Yep.
Yeah.
Just kind of sounds like an issue of not really understanding how things work. Or, perhaps there was some contention, like you said. Perhaps the brother thinks, they were never married, therefore she has no rights, so.
Right.
Anyway.
Who knows?
Who knows?
That's a good one.
That was a good one. All right. Yeah. All right. Well, thank you. Thank you so much, David, for your time and for your wisdom and your knowledge. We all appreciate it. So for those who are watching, David, just let everyone know, how can they reach out to you if they have any questions about real estate law, finance, contracts, estate planning, probate, etc.
All related to real estate.
All related to real estate, right?
Just 888-789-1715, or you can go to provenresource.com. You could go to the URL on the web, on the what do you call it, the search engine, and just type in my name. Sobel has to be spelled S-O-B-L-E.
Go to the Google.
Yeah, go to the Google, and you know, at risk of sounding immodest, I should pop right up.
Right up. All right. All right.
And we should be doing these investor network programs soon, right? Like in person, do you know, or?
I don't know when we're going to be able to get back in person. I know that some networking groups have gotten back in person, but not so sure when ours is going to.
Okay.
But all
So
right.
soon I'll be able to meet people there too.
Right, exactly. So whenever the world opens back up again, you can see David live and in person, not just over YouTube. All right. Well, thank you so much, David. You have a good night.
Thank you, Blair. You do the same. Thank you.
All right. And thanks everyone for watching. Take care.
Bye-bye.